Good morning if you're joining us on YouTube. Welcome to Probate Court 2. I'll remind you that recording and or reproduction is prohibited. Hi Kathleen, I'm letting you in first, so I'm going to allow you to record. Good morning if you're joining us on YouTube. Welcome to Probate Court 2. I'll remind you that recording and or reproduction. Okay. All right, do you have the ability to record? You're on mute.
Sorry, I am up and on. All my software is going. Thank you for asking.
Okay, great. And you're able to record want to off Zoom?
No, not that I'm aware of. That has never been a thing us reporters have done. Only videographers have done that through depositions.
Okay, well, if you want to, I know our normal court reporter, she records off of Zoom. So I've given you permission to record the proceeding. And then you can go back and see who's talking and all that stuff if you need to complete the record. And if you're joining us on YouTube, I'll remind you that's why you are not allowed to record or reproduce, is because our court reporter is taking the official record. If you do record this proceeding or you do reproduce this proceeding, you can be held in contempt of court. All right, I am going to mute you again and we'll let everybody else in and begin.
Thank you. You're welcome.
Good morning and welcome to Probate Court number 2. We are here in the matter of the estate of Norma G. Amos, and that's cause number 2019 PR 03478-2. And we're here on the contest of the probate of a will. But from what I can see, all parties seem to want to probate the will. It's just an issue as to whether one or three or none will serve as administrator, and then if that administration will be independent or dependent. I know Ms. Clay asked y'all to file a hearing letter with who your witnesses and things would be. I didn't see that from either of you. So is there a settlement or an agreement?
There's no agreement, Your Honor. I'm not sure. I guess we must have just not noticed as far as the witness list. I do have my applicant, Ms. Warnicky, here.
Mr. Pearson, you're on mute.
Is this better?
Yes.
Okay. I also have my applicant. And I think there's going to be the only two witnesses. Andrew?
Well, I am going to ask you guys to file those next time so that we know who we're looking for and all that good stuff. Yeah, she sent that email and she filed it with the clerk asking y'all to do that. All right, well, go ahead and announce yourself and who you represent.
My name is Andrew Siebert, and I represent the applicant, Terry Warnicky.
My name is Gray Pearson. I represent applicant Connie Holden.
Okay, and have I kind of summarized everything correctly? You both want the will admitted, but it's a disagreement as to who should serve. Is that correct?
That's correct.
Mr. Siebert, is that correct?
Yes, that's correct, Your Honor.
All right.
Kristen?
Mr. Siebert, it looks like you guys filed first, so I'm going to let you start.
All right, thank you. I'll just point the camera at Ms. Warnicky.
Okay, and do you have a notary there to swear her in?
I am the notary, Your Honor.
Okay, there's a Mr. Hubble that's joining us. I will tell y'all that if somebody joins us, I let them in. just as if they were in the courtroom, because evidently you can come watch in the courtroom, but you can't seek justice because the virus will get you if you're seeking justice. But not.
Your Honor, it's not actually Mr. Hubble. It's Mr. Hubble's computer with my witness, I believe. Oh, well, looked like it was Mr. Hubble. Well,
Now that's the problem with Zoom. It was a picture of Mr. Hubble, not necessarily a video. So half the time we don't know who's in here, even if it says their name on there. And there's no way to see if Mr.
yes, it's my witness.
Okay. All right. Mr. Siebert, why don't you go ahead and swear in your witness?
Tell the whole truth, nothing but the truth. Can I proceed, Your Honor?
Okay, Mr. Siebert, I didn't hear any of the oath, but I did hear your client say I do, so I think it was done, but you're gonna have to speak into the camera or into the computer.
All right. Can you hear me okay now?
It's okay.
All right, how about now?
That's better.
All right. Would you state your name, please?
Terry Lee.
And where do
Okay,
you
Ms.
live?
Warnicky, you're gonna have to speak up a whole lot more. I could see that you said your last name, but I couldn't hear it.
Terry Lee Warnicky.
And where do you live?
In Mount Washington, Kentucky.
And how are you related to Norma G. Amos, the decedent?
She was my mother.
At the time of her passing, were there 4 children of Miss Amos living?
Yes.
Were they?
Connie, Holden, myself.
Who?
Connie, Holden, myself, Terry, Carol Slider, and Richard Amos.
Has your brother, Richard Amos, passed away this year?
Yes, he has.
Did Norma Amos pass away on or about July 12th, 2019 in Tarrant County, Texas?
Yes.
Was Miss Amos 86 years old, residing and domiciled in Tarrant County, Texas immediately prior to her death?
Yes.
Let me show you what's been filed with the court. Do you recognize that document as the last will and testament of Miss Amos dated December 29th, 2015?
Yes.
To your knowledge, did Miss Amos pass away without revoking her will dated December 29th, 2015? So did she pass what? Did she ever
Mr.
revoke?
Siebert, I couldn't even hardly see her lips that time, but I think she answered and we didn't hear a thing. Or I didn't hear a thing. I have no idea what other people heard. That's another problem with Zoom is it may freeze on one person's, but not on the others.
I could not hear it, Your Honor.
Okay, let me repeat. To your knowledge, did Miss Amos pass away without revoking her will that was dated December 29th, 2015?
Yes.
Was there any child or children born to or adopted by Miss Amos after execution of the will?
No.
Time of the execution of the will was Miss Amos of sound mind and at least 18 years of age.
Yes.
Did Miss Amos have a marriage dissolve after the will was made? As 4 years
I heard, I didn't hear anything. I just read her lips to say no. I'm going to need you to speak up. I don't know if it's something with the camera or what, but Ms. Warnicky, you're going to have to speak up.
Yes, Your Honor.
louder than that.
We can't hear her. You need to talk towards the computer.
Talk all the way out there. All right. Has 4 years elapsed between Miss Amos's death and the date when the application for probate of Miss Amos's will was filed?
Yes.
No. Has 4 years elapsed?
Oh, yes, 4 years has lapsed.
Mr. Siebert,
Yes.
you can't testify for your client. You can ask her a follow-up question and you can clarify, but you can't tell her the answer and then ask her another question. This is as if we were in the courtroom, even though it's clearly not.
Correct. I'm sorry, Your Honor. Let me re-ask the question. Has 4 years passed since your mom died?
Yes.
When did your mom die?
Oh, well, no, I'm sorry. A year ago.
Okay. All right.
I misunderstood. I'm sorry, Your Honor.
Fine, just ask me to repeat it or rephrase it, okay? Loud. Okay.
Okay,
Is the state of Texas or any charity a devisee under Miss Amos's will? Does the state of Texas or any charity get anything under the will?
no,
Were you named as one of the independent executors of the estate in the will?
yes,
Were both your sisters named as co-executors?
yes,
In her application, your sister, Miss Holden, has stated that it is impossible for there to be co-executors at this point. Do you agree with that assertion?
yes,
Did you have access to the original will?
no,
Did you have access to the funds in your deceased mother's account?
no,
Did your sisters?
yes,
Did either of your sisters file to admit the will to probate before you did?
no,
Did either of your sisters?
I'm sorry, I cannot hear the witness. I apologize. I cannot hear the witness.
She said no.
Did either of your sisters file anything in the probate court before you did?
no,
Why did you first approach my office?
so the will would be probated.
Okay. Had
Was
you
that
heard
for the will to be probated?
So the will would be probated. Yes, Your Honor.
I'm sorry, Your Honor. I know this is frustrating, but I have my microphone turned all the way up, I promise.
Well, Mr. Siebert, it's not necessarily you. This is the Texas Supreme Court and the Office of Court Administration have put our justice system in this quandary.
So I will encourage Ms. Warnicky to speak up. That's all I know to do.
Okay.
Had you heard whether or not assets, including furniture and monies, were being distributed from the estate?
Yes,
Okay. Did you request?
No?
yes,
Yes. Okay.
Did you request through my office an explanation and accounting of what has occurred after your mother passed away?
yes,
Did you receive some information?
no.
Did you?
No,
I didn't receive any information.
I can't hear.
Will.
I couldn't hear that. I'm sorry.
I received no information about the will.
Okay. Mr. Siebert, I'm going to ask you to look at the email you received with the Zoom information. There also should be some information on calling in. So you can leave your video on and I'm going to mute it. And hopefully we can get better audio if you can call in on the phone as well. While you're doing that, I'll just remind everybody, if you're watching us on YouTube, welcome to Probate Court 2, and you're welcome to watch us, but you are prohibited from recording and or reproducing in any manner. You can be held in contempt of court. We are forced to do this per the Office of Court Administration and the Texas Supreme Court, which have been given that power through the emergency orders in the state of Texas. I have been an advocate for opening our courts for many reasons, but you're seeing a lot of them right now as far as people not being able to hear or some computers freezing and others not. And it is unfortunate that they are tying our hands. For judges who do have an in-person hearing, they subject themselves to a judicial ethics complaint. And the standards of having an in-person hearing are murky at best without any guidance. So unfortunately, litigants in the state of Texas are being forced to do this, as well as judges. Our hands are tied. This is certainly not how I prefer to run my court. I think that we could take reasonable precautions and have people in here seeking justice in a safe manner. And prior to June 1st, we actually were able to have essential hearings in person. And of course, we took all the precautions that were necessary, and we had no cases of COVID and certainly no spread. I've got to do a shout out to our clerks. They have had their people working here and back for many months now, and they have had cases, but it has not spread in the courthouse because of the reasonable precautions they are taking. So our clerks can have people back in the courthouse working for you, but our judges and our court staff, our hands are tied. So this is what we get. I encourage you to contact the Texas Supreme Court and the Office of Court Administration and ask them to open our Texas courts. Mr. Siebert, I see you muted yourself and there is your phone. Okay, I'm going to admit that and hopefully that will work better. You're going to have to unmute yourself on the phone. And that was perfect timing for me to explain everything that's going on with our justice system right now. Once you unmute yourself with the phone, we should be able to see if it'll work a little better. I know the computer prompts you to unmute yourself. I assume if you talk into the phone and you're on mute, it will prompt you on how to unmute. Unfortunately, I am not able to unmute you.
Judge, I'm back on the computer because I've pressed *6 for the instructions on my phone, and it's not obviously unmuting me on my phone.
Okay. All right, then I'm going to put your phone back in the waiting room, but I can tell if you get unmuted on your phone, and then we can try again. No. Actually, try that again. I just took you out and put you back in. Will you hit *6 one more time? See if it works.
How about now?
No. Okay.
I can hear myself through. Oh.
All right. I'm going to have to put you in the waiting room because otherwise we're going to get the feedback. All right. We'll just continue through this. I don't know where your microphones are or anything, but just try and speak towards the microphone, both of you.
All right. Judge, can you hear me?
Yes.
All right. We'll proceed. And at some point in time, Ms. Warnicky, did you ask for an accounting or some sort of explanation of what happened to your mom's assets?
Yes.
And did you receive any information as to that?
No.
Okay. And have you become aware that some of the assets were distributed?
Yes.
Well, how did you become aware of that?
From my brother.
Right.
Objection hearsay.
From her brother.
From my brother.
Objection hearsay.
At some point in time, were you furnished a list of items from your mother's estate with notations as to what happened to them?
Yes.
Okay. And were some of those items gifted or given away or distributed?
Yes.
Were you consulted before any of those items were given away or distributed?
No.
Did you agree, or were you given a chance to agree or consent to any of those items being distributed?
No.
Are you still learning what was distributed, or do you believe there's additional things that may have been distributed that you don't know what happened to?
Yes.
Is any part of your application based on just simply not getting along with your sister?
No.
Can you identify some of the assets that you understand were given away?
Okay, we can't hear. She,
Curio cabinet,
no, we can't hear that.
a curio cabinet, my mother's jewelry, which consists of rings and necklaces, an angel collection, china, dishes, silverware.
And are you opposed? One of the things that your sister has put in her application is that if she's not chosen, a neutral administrator be appointed. Are you opposed to that?
No,
Do you think that the estate can afford a neutral administrator?
no,
Okay. So would you be in favor of a neutral administrator, or do you think you're the most appropriate person?
I feel I am.
You filed your application in December 2019, correct?
Yes,
Did you request the original will as part of that?
yes,
Were you provided the original will? Have you ever been given the original will?
yes.
Well,
A copy I
okay.
have seen.
I know you've seen a copy. Have you ever been given the original of the will?
No,
When did Ms. Holden file?
Oh, can't, Mr. Siebert, I can't hear you. Mr. Siebert, if you're talking, I can't hear you.
No, Judge, I was just, I continue to try and make this better.
Okay.
But let me re-ask. Does a necessity exist for the administration of this estate?
yes,
Have you ever been adjudicated incompetent?
no,
Have you ever been convicted of a felony?
no,
Have we discussed the requirements and duties of an executor of an estate?
yes,
Are you aware of any reason why you should not or cannot serve as independent executor?
no,
Are you asking this court to appoint you as the sole independent executor and issue letters testamentary without bond and without fee?
yes,
Thank you. I'll pass the witness.
Yes. Good morning, Ms. Warnicky.
good morning.
Ms. Warnicky, you say there's a necessity for administration. Why?
I just don't feel things will get resolved
What would you expect to do as part of that administration?
to make sure things were fair.
And how would you do that?
Consider what there is of the estate and make sure it's divided equally.
Now, you say the application has nothing to do with your not getting along with your sisters. Is that correct?
Correct.
All right, let me just ask you, do you recall a text message that you sent on the day of your mother's funeral to my client?
Yes,
Let me read it to you and see if I read it correctly. Would you please listen to me?
yes,
Me and none of my family or friends will be anywhere around you thieves and liars. Don't ever contact me again. You are dead to all of us. Did you write that, ma'am?
yes, I did.
All right. And did you actually even show up at your own mother's funeral?
I was there, but I was across the street.
So
I was told not to associate. I was told not to associate with either of them.
Now, what do you think that my client, Connie Holden, is wrongfully put into her pockets?
A lot of items that were my mother's possessions, jewelry, money, different things of that nature.
So you think that my client has all these items?
Not all of them.
On what do you base this opinion?
I base this on information that was written down when she had done an inventory of all the items
Okay. Now,
that she gifted.
since your mother died. Your brother has also died, correct?
Correct.
And he died without issue, is that correct? No children,
No children.
no family.
Correct.
All right. Now, isn't it true that about just a few days before your mother died, and when she did not know she was dying, she decided to make a distribution of some of her assets?
I was told that she was distributing was distributing.
Did you get a check for $50,000?
Yes.
Was it agreed that all four children were to get a check for $50,000?
Yes.
Now, did Rick actually get his full 50,000?
Not in his possession.
Who possesses it?
My sister, Carol Slider.
Have you made demand upon Carol Slider to return it?
No,
Why not?
I have not talked to her. I do not know where she is.
When's the last time you talked to my client, Connie Holden?
Would been, let's see, was when my mother's funeral was being set up by me.
Now, do you recall an episode that took place in Thanksgiving 2015?
Objection, Your Honor, relevance.
I'm not sure that she had no relationship with her mother, Your Honor.
Again, relevance of what happened in 2015. They could have hated each other in 2015. The will was.
Mr. Siebert, I sustained your objection.
Oh, thank you.
I passed the witness.
Any other questions, Mr. Siebert?
No, Your Honor.
Okay. You have any other witnesses?
No, Your Honor.
Okay. Are you resting?
Yes, I'm sorry.
Okay. Mr. Pearson, you may call your first witness.
We called Connie Holden.
Okay. And is there a notary with her?
Kristen, are you in there with Connie? Hold on.
Okay. Okay. I'm going to ask Ms. Holden if you'll unmute yourself while Mr. Pearson is, I think, coming into y'all's room.
Okay, I'm right here. I'm unmuting her.
Okay. Ms. Holden, I'm going to ask you to raise your right hand, and the notary is going to ask you if you swear to tell the truth, the whole truth, and nothing but the truth. So help you God.
I do.
Okay. Didn't hear any of the oath, but I did hear you say I do. So I assume you are duly sworn.
Please state your name for the record, Ms. Holden.
Connie Lee Holden.
And Ms. Holden, you've heard the allegations made by your sister, Terry Warnicky. Is that correct?
Yes, sir.
Now, are you over there? Are you spending your mother's money on yourself?
No, sir.
Okay. Now, is it correct that immediately prior to her death, your mother made a distribution of some $200,000, 50 to go to each of her children? Is that right?
Yes, sir.
But the total amount was about $250,000. Is that correct?
Yes, sir.
Now, you got your 50,000, Carol got her 50,000, and Terry got her 50,000, right?
Yes, sir.
Right. Now, with respect to Rick's 50,000, what happened to it?
It was put in an account by my sister, Carol Slider, to provide him money while he was incarcerated.
Do you know how much that money is still left?
I'm going to say approximately $45,000 because she paid for his cremation and stuff through the funeral home after he passed away.
Right. Now, but there was the total amount of the money was, as I understand it, was $250,000. Is that correct?
Yes, sir.
What happened to that other 50,000?
It is in an account in Carol's name. I can explain that my mother asked her to move it. And
Okay.
that's why it's in her name.
Why did your mother ask you to move the money?
She was concerned that she was going to be put into a nursing home and wanted her money not in her name for fear that it would all be taken away from her, and that's not what she wanted.
Now, we're talking about the money that in the Kiesler Credit Union, right?
Yes, sir.
Okay. Now, since your mother died, have you had conversations with Carol about returning that money so that it can be distributed between the three sisters?
No, sir. She's vague on.
No, that wasn't the question.
Oh.
Have you had conversations with her about doing that?
No, sir.
You've had no discussions or communications with Carol at all about returning the money?
No, sir.
Well, you say she's vague, then I don't understand what you're talking about.
When we talk about the money, the conversation doesn't go anywhere.
Now, you were named one of the executrixes of the estate, right?
Yes, sir.
Now, have you expressed your concern to me that Carol has not returned the money?
Yes, sir.
And have I explained to you that it may belong to the estate, but that nothing can happen until the estate has a personal representative?
Yes, sir.
Assuming that you're appointed as the personal representative of the estate, are you planning to take whatever action is necessary to get that money back from Carol?
Yes, sir.
Now, what about the other assets? You heard Terry say that you'd been giving away all of her mother's assets. What's the story on that?
Before my mother died, and Terry knows this, before she left Kentucky, she divided up her things. She gave Terry things. She gave things to her husband and to Terry's children. She also said that, for example, her 3-bedroom suit, she gave one to Terry and she gave one to the other 2 sisters. She also gave the china to Carol, and she gave Carol 2 rings, those angels, and she gave me the silver and the living room furniture that we had bought once she moved down here, because she donated all the other stuff she had to the Veterans Organization. And I want to make one comment, Ray, that I believe Carol is waiting for the court to tell her what she has to do with that money. I think that's what her statement was to me many months ago.
Do you think the money needs to be returned to the estate and then distributed between you, Carol, and Terry?
I do, but I don't know what Carol's intentions are. But yes.
I understand that we don't know what Carol's intentions are, but if you're appointed as the executrix, would that be your intention?
Yes, sir, it is.
Okay. Now, what personal property did your mother have left when she moved down to Texas of any value? That she had not given away already?
Her clothing, pots and pans, rugs, linens, just household things, because she had already sold her home and she didn't have anything other than her personal possessions.
And was she living with you at the time of her death?
Yes, sir, she was.
How long had she been living there with you?
She had been living with me since June of 2016 when she left Kentucky.
Okay. Do you realize that if you were to be named as sole independent executrix, that you have a fiduciary duty to Terry? Whether you get along with Terry or not, you have a fiduciary duty to her to make sure that she gets her correct part of the estate. Do you understand that?
Yes, sir, I understand that. Yes, I do.
And are you ready to honor that duty if you're so appointed?
Yes, sir, I am.
Now, I believe there was also another 18,000 in a Bank of America account. Is that right?
Yes, sir, there is.
And is that money still there?
Yes, sir, it is.
Is that going to be part of the estate also to be distributed, whatever is left over?
Yes, sir.
Expenses.
Yes, yes, sir.
Is there anything else of value in the estate?
There are a few pieces of jewelry, things that are to go to Terry that has not been given to her yet. It was listed on that inventory that was sent to the attorneys that showed what possession, what my mother had wanted her to have.
And on that inventory, did you mark that those were to go to Terry?
Yes, sir, we did. And I was not the one that decided those things. Those were, my mother made that clear to all three of us and my brother, how she wanted her stuff distributed.
Now, I believe there's only one other asset that we haven't talked about. That was your mother had a car. Is that right?
Yes, sir, she did.
And did Carol buy that car?
Carol did buy the car. Yes, sir.
All right. Has Carol paid for the car?
She hasn't distributed the money to everyone yet. No, sir.
Okay. Is that something else that you need to go after, well, deal with respect to Carol?
Yes, sir.
No further questions. I pass the witness.
Mr. Seibert?
Ms. Holden?
Yes, sir.
You bring the original of the will into your attorney, Mr. Pearson, correct?
Yes, sir, I did.
So you had possession of the original will the entire time, correct?
It was in a file that my mother maintained, and then once she passed, I got the stuff out of the file she had. And if the will
Sure.
was in it, yes, sir.
And she was living with you at the time she passed, correct?
Yes, sir, she was.
All of the jewelry, the furniture, the car, the assets you just described were all in Texas with you, correct?
Yes, sir, they were.
Carol does not live in Texas, does she?
No, sir, she doesn't.
Okay. After your mom passed in 2019, you never sought to open an estate, did you?
Yes, sir, I called an attorney and asked them if the will needed probated because Terry said it needed probated. He said that because there wasn't really anything in her estate, that it didn't need to be probated in the state of Texas. That was it was an optional thing. And so I expressed that to both the sisters, and Carol was all right with it, but Terry was not.
In September of 2019, you received a letter from me on behalf of Terry requesting an original of the will as well as an accounting, correct?
Yes, sir, I did.
And you did not give us the original of the will, correct?
I cannot hear what you said, sir.
In spite of my letter asking for either the original of the will, well, asking for an original of the will and an accounting, you didn't give me the original of the will, did you?
I got Gray Pearson and went to him before I sent anything off to see what I had to do.
Okay. And in spite of that, you never filed again in 2019, you never filed a small estate affidavit or anything with the probate court, correct?
No, sir, I didn't go to the court with that. No, sir, I hadn't been advised to do that.
In fact, Terry filed the application to probate this will and become executor in December of 2019, and you didn't file your cross application until 4 months later in March, correct?
I was following the advice of my attorney.
I just need a yes or no, ma'am. Is that correct?
No, I didn't.
Okay. And the fact of the matter is, you have never had anything like a family settlement agreement or anything in writing in which Miss Warnicky or Carol or your brother agreed to any of the distributions that you made up until this point, correct?
No, sir.
no, that's not correct? Or you agree that you don't have anything like that?
My mother did not put in writing what she wanted. She
It-
expressed it to each one of us. And so, no, sir, I don't have it in writing.
And do you have a bill of sale or anything from when Carol purchased the car?
Yes, sir.
Okay. And in spite of the fact that you gave Carol access to the vehicle and the keys to the vehicle, and she promised to pay, she still hasn't paid, and you still didn't pursue anything until Terry filed the application, correct?
No, sir, that's not correct. I have the car, I have the keys. It is not in Carol's possession.
Okay. But you
Terry
sold it.
filed the lawsuit, and so yes,
Oh, so it was in her possession, or she was about to take possession, but she hasn't? Or did she give it back to you?
no, sir, she has never been to Texas to pick up the car because all the stuff with my mother started. So we did not do anything once the lawyers were involved, but the car is in my possession. It's
Have you-
titled in my name.
And you knew that there was this 250,000, of which $200,000 got distributed. You knew about this $50,000 being in Carol's possession, obviously since before your mother had passed, correct?
Yes, sir.
And you say that she may be waiting for an order from the court to give up this $50,000, but if it weren't for Miss Warnicky pursuing this matter, apparently you would have never filed anything in the court, correct?
No, sir. My name and Carol's name are listed as the joint co-owners of that account, and we are also listed as the beneficiaries of that account. However, we were going to divide it between the 4 siblings. It
And
is not under anybody else's name.
so you've testified that Carol hasn't given the money back, and if you were appointed as executor, that you would pursue it. And so I'm just wondering why from July 2019 all the way to March 2020, you took no steps to do that.
Advice of my counsel to not do anything with my mother's estate until it was settled.
And everything that you've distributed, and you admit that you've given away, you've made a gift of china, you've made a gift of jewelry, you've made a gift of furniture, you've donated items, all of those things, you don't have anything in writing saying this is what we agree to do with these things. You're basing all this on what you testify was your deceased mother's intentions, correct?
Objection, mischaracterizes the testimony. I believe her testimony was that China was given by the mother to Terry.
Mr. Pearson, you can say your legal objection, and you're going to have a chance to ask your client questions. So Ms. Holden, you can answer the question.
All right. Can you please repeat it?
Sure,
Some of it was broken up when you asked.
sure. You've based your thoughts on distribution and giving away and donating and distributing all of the assets we've talked about based on what you contend was your deceased mother's intentions, correct?
Okay, it's froze again. Okay, I'm not sure that I heard the whole question again, but can tell you this, that all of those things are still in my possession. They are listed on that spreadsheet because that is what my mother wanted. So that's why they're listed that way, and that was the intention. But they are still in my possession.
Okay. And so, but those intentions were never expressed in the will, correct?
I forget exactly how things were in the will, but I believe it was to be distributed equally.
And there was never a handwritten item or list of items that was in your mother's handwriting attached to the will, correct?
No, sir, there wasn't.
So because you didn't pursue getting any kind of agreement amongst the different beneficiaries, we have your interpretation of what your mom's intent was, and we may have at least one or two other statements of intent, correct?
Yes, if you were to talk to my other sister, I'm sure she would basically tell you the same thing that I did. And also, my mother had mentioned things to my husband and my mother-in-law, but I don't know if statements from them would be necessary.
Your Honor, I'll pass the witness.
Mr. Pearson?
Yes, Connie.
Yes, sir.
Now, after you received the letter from Mr. Siebert, did you come to my office to see me?
Yes, sir, I did.
And
Yes.
at that time, did we promptly provide Mr. Siebert with a correct copy of the will? To the best of your knowledge.
I'm sorry, Gray, I did not hear all of that.
Is it correct that you provided the
You
will?
froze. Could you please repeat it?
Is it correct that you provided the will to me and I provided a copy to Mr. Siebert? Do you understand what I'm saying?
Yes, sir.
Is that correct?
I heard part of that question. And yes, I did come.
No, listen again.
Okay, Mr. Pearson,
Yes.
it's a problem. Her
Heard it.
screen keeps
Hear
freezing.
anything?
So when her screen freezes, she can't hear you. It's frozen right now, at least from what I can see.
Your Honor, to make things easier, I'll stipulate that at some point in time, I got a copy of the will from Mr. Pearson.
Go ahead, Mr. Pearson.
Connie, can you hear me?
Yes, sir. Now I can hear.
Connie, come into my office. Just come into my office. We'll use my computer.
Okay, yes, sir.
Yes, sir.
Come on here.
Okay.
Okay.
All right.
Come here. Here. You sit in my chair. You sit in my chair.
Sure.
Yeah, you sit in my chair. All right.
Okay.
Okay, here we go.
All right.
Okay. Your Honor, can you hear us?
Yes.
Okay. Connie,
Yes, sir.
after you received the letter from Mr. Siebert, did you come to see me and bring me a copy of, either the copy or original of the will?
Yes, sir, I did. I brought you the original.
And was it, as far as you know, did I then promptly provide it to Mr. Siebert?
Yes, sir, you did.
At his request, he wanted an inventory. Did you provide such an inventory?
Yes, sir, I did.
And on that inventory, did you list the specific personal properties is in the category that your mother had made it clear to all three daughters that she wanted distributed?
Yes, sir, I did.
Have you heard one single complaint from Terry that, no, this isn't what mom wanted?
No, sir, I haven't.
Now, earlier, there was, I believe, testimony that the estate could not afford an independent administrator if that were to be the case. In fact, there's $18,000 in the bank account, right?
Yes, sir, there is.
Plus, the estate is owed $50,000, from Carol. Plus, there's still the $45,000 left over that belonged to Rick that has no place else to go but this estate, right?
Yes, sir.
So, in fact, there's plenty of money to fund an independent administrator should the court so decide.
Yes, sir.
Okay. I pass the witness.
Mr. Siebert?
I don't have anything else, Your Honor.
Okay. Is there any objection to the will being admitted to probate?
None.
Okay. It's not really been proved up. So Ms. Holden, I'm going to need you to sit down. Ms. Holden,
Yes, sir. Yes, ma'am.
it's my understanding you were in possession of the original will after your mother passed away and you delivered it to Mr. Pearson, correct?
Yes, sir. Yes, ma'am, I did.
And is it your understanding Mr. Pearson delivered it to the court?
Yes, ma'am.
And are you familiar with your mother's signature?
Yes, ma'am.
I have what I believe to be the original. I'm going to show it to you. It has been file marked.
Yes, ma'am.
It is typed on all pages until we get to page 3, and then there's typed and handwriting. What I'm pointing to, is that your mother's signature?
Yes, ma'am, it is.
And the last page is page 4. Does this appear to be the original of the will?
Yes, ma'am.
Okay, thank you. All right, any other questions for this witness?
No further questions from me, Your Honor.
Okay. Mr. Siebert, I couldn't hear you, but it seems you said no.
That is correct. No, Your Honor.
Okay. Mr. Pearson, you can call your next witness.
We rest, Your Honor.
Okay. All right, I need Ms. Warnicky on the screen and Ms. Holden on the screen, please. All right. Ladies, it's unfortunate that you guys don't get along. I am put in a position to either appoint one of you as a dependent with bond, appoint both of you as dependent with the bond, or appoint a third party. From what I can tell, there might be about $68,000 in cash in this estate, plus whatever the car is being sold for and a few other things. And I can tell you that if I appoint a third party, or even if I appoint both of you or one of you and you continue to fight, the person who, or the persons who are going to get that $68,000 will not be you, and it will not be Carol, and it will not be whoever will be the beneficiaries of heir or heirs of Mr. Amos's estate. It will be the attorneys, because you both have fine attorneys. If I appoint a third party, that will be a fine attorney, and they will get paid for their services. So I'm going to take this under advisement for a week, and I'm going to strongly encourage y'all to come to an agreement as to who's going to serve, or an agreement that no administration is necessary because you're going to divide the assets out. Seems like, I don't know about the 18,000, but everything else seems to be in other people's names. And again, you guys can get along and you can figure it out, or the attorneys are going to wind up with the $68,000 and you guys might still get a ring or necklace, or you know what, those things may have to be sold to pay the attorneys as well, which they are going to be sold to pay for administration of an estate before they would be distributed. So I'll take this under advisement for a week. I'm going to ask the attorneys if there is a settlement, if you will please file something by noon on the 13th. No, excuse me. I'm going to give you noon till next Friday. Noon to next Friday. I'll be ruling Friday afternoon if there's not an agreement. And attorneys, if you guys do get an agreement, if you'll file something saying such, and also let Ms. Clay know, because sometimes the filings aren't as quick as we are looking to rule. So thank you today. Like I said, you're both represented well, but it would behoove you to try and figure it out and get an agreement. Anything else for today?
No, thank you, Your Honor.